Imagine a father sending a photo of his newborn to his family halfway across the world, or a journalist contacting a confidential source to uncover corruption, a lawyer discussing a sensitive case, or even just a doctor reassuring a really worried patient with their test results. Now, all of these daily, seemingly mundane interactions begin with one foundational assumption, that they are private, that no one else is listening in. Well, in this explainer, we're looking at a story that impacts literally everyone who uses a smartphone. It's a story that requires us to understand how our digital lives are built and, honestly, how quickly those foundations can shift, because embedded in a recent, highly urgent legislative push is a little detail that might make you question everything you type, especially when you find out who exactly gets an exemption from these new rules. To really understand the gravity of what's happening right now, we first need to take a step back and look at why confidential communication has historically mattered so much to us. It isn't just about hiding secrets, It is the absolute bedrock of a free society. It's the space where trust is built, where free expression breathes, and where human rights organizations can actually operate safely. I mean, think about it. Most people only speak entirely honestly when they trust they aren't being watched. For centuries, liberal democracies have operated on this principle that your private conversations are your own, unless a judge signs a specific warrant based on a specific, documented suspicion. That has always been the legal and moral standard. And the standard for this privacy has constantly evolved alongside our technology. Back in the 18th century, the guarantee of privacy was a literal wax seal on a physical letter. If that seal was broken, the law had been violated. Moving into the 20th century, that protection extended to the telephone. Wiretapping a call without a strict legal warrant was a severe violation of civil rights. Today, in the 21st century, the modern expression of that ancient right is the encrypted chat. Digital privacy is not some new luxury or a clever loophole. It's simply the exact same fundamental right transferred to a new medium. A secure digital lock is, for all intents and purposes, today's wax seal. But what happens when the architecture of that privacy is fundamentally altered? What if the assumption that your private communications are truly private is just no longer valid? Now, this isn't some hypothetical question from a dystopian sci-fi novel. It is a very real, immediate question, and the catalyst for it is a recent, highly urgent legislative vote that just took place in the European Union. And as you'll see, the outcome of this vote sets a precedent that could redefine digital freedom not just in Europe, but globally. So this brings us to Brussels, and a piece of legislation colloquially known as chat control. Now, the official goal of this proposal is deeply, undeniably important: combating the distribution of child sexual abuse material, or CSAM. The European Commission argues that to protect children online, tech companies need the authority to scan messages for this horrific material. But the mechanism proposed to do this, actually scanning private messages, is incredibly controversial. In fact, earlier this year, the European Parliament actually rejected an extension of these exact scanning rules. But then, proponents of the law pushed it through anyway. They used this rarely used urgent procedure right as many parliament members were away for the summer recess. And when you look at the math of this vote, it reveals something really startling. 314 members voted against the measure. Only 276 voted for it, with 17 abstentions. So a clear majority of the people in the room voted to reject chat control. Yet the proposal passed. You might be wondering, how does that work? Well, under this specific procedure, opponents needed an absolute majority of all elected members, which is 361 votes, to block it. Because so many were absent for the holidays, that threshold wasn't met. So despite a majority voting no, the legislation moved forward anyway. It's a striking example of procedural maneuvers determining the future of fundamental rights. So what exactly did this vote do? Well, it extended what's known as Chat Control 1.0 until 2028. Basically, this means platforms like Meta, Google, and Microsoft can continue voluntarily scanning unencrypted messages, emails, and photos without a warrant. However, there was a vital amendment passed. Communications that use end-to-end encryption, like WhatsApp or Signal, are currently exempt. A representative from the Pirate Party called this a bittersweet victory, because while it preserves encryption for now, the mechanism for mass scanning still passed. But remember, this is just temporary. The real battle over Chat Control 2.0, which would be a permanent and mandatory scanning law, resumes in September. To understand why this battle is so fierce, though, we really have to look at what this law physically requires your phone to do. To truly grasp why this debate is so intense, we have to look under the hood. How does a tech company actually scan millions of private messages every single day? It's one thing to debate policy, but the technology dictates the reality. Proponents say the scanning is targeted, but cybersecurity researchers argue that the infrastructure required to do this fundamentally changes how our devices operate. Because, think about it, how do you actually scan billions of private messages before they're even sent? Well, this process is known as client-side scanning, or CSS. Here's a really helpful analogy. Imagine a post office. Traditionally, you seal a letter, you drop it in the box, and the post office delivers it. They don't look inside. Client-side scanning is basically like the post office placing an inspector inside your house. Before you can even put the letter in the envelope, the inspector reads it, checks it against a list of forbidden content, and only if you pass are you allowed to seal it and send it. The scanning happens locally on your phone, your tablet, your computer, before the message ever enters the delivery network. Now, the primary tool used here is called hash matching. It essentially turns known illegal images into unique digital fingerprints, or hashes, and checks if your photos match. But Chat Control wants to go further. They want to use artificial intelligence to detect new, unknown material and even grooming behavior. And this is exactly where experts raise massive red flags. Cryptography professors warn that AI is much, much less accurate with unknown material. When you're scanning billions of messages a day across Europe, even a tiny fraction of an error rate means millions of completely innocent citizens could have their private family photos falsely flagged and sent to the authorities for review. And this brings us to the ultimate technological clash: end-to-end encryption versus client-side scanning. End-to-end encryption means only the sender and the recipient hold the keys to unlock the message. Not even the app provider can read it. But if the law mandates client-side scanning, it effectively mandates a backdoor. If the app analyzes the content on your device and reports it before it gets encrypted, that secure digital lock has been bypassed entirely. You simply cannot have a secure communication system if a third-party algorithm is legally required to inspect everything you write. It's an oxymoron. So naturally, this technological reality has sparked arguably the most significant privacy debate of our generation. The tension here isn't a simple story of good versus evil. It is a profound clash between two fundamental societal values. On one hand, you have the moral obligation to protect the vulnerable, and on the other, the democratic necessity to protect civil liberties. On one side, the supporters of the legislation have an absolutely undeniable moral imperative. Children are being exploited, and sophisticated grooming networks operate across borders. The European Commission and child protection advocates argue that tech companies just cannot be blind to the horrific abuse material flowing through their servers. They point out that traditional policing is not enough and that we must leverage technology to detect and stop predators before more harm is done. For proponents, waiting around for a specific warrant is just too slow when dealing with the rapid, viral spread of abuse material online. But on the flip side, civil rights organizations, cybersecurity researchers, and privacy advocates are raising urgent alarms. Take this quote from European Digital Rights: "Client-side scanning is mass surveillance by another name." Opponents argue that you don't fight crime by installing cameras in the bedrooms of innocent people, and you shouldn't fight digital crime by treating every single citizen as a suspect. They warn that breaking encryption actually exposes the public to way greater cybersecurity risks from hackers and hostile states. Basically, building an infrastructure to monitor everyone's private thoughts creates a digital panopticon that fundamentally alters the balance of power between the citizen and the state. To really understand the broader societal impact, we can look at the Scanning Liberty Away report. It's a critical study of this proposal that points out the massive chilling effect this would have. Think about journalists communicating with whistleblowers, or NGOs supporting refugees, or protest groups organizing legally. If their secure communication is compromised, they face immediate, real-world vulnerabilities. Furthermore, European businesses, especially small and medium enterprises, could face massive compliance costs and reputational harm as global trust in Europe's digital economy begins to erode. Legal scholars actually have a term for this. They call it the ratchet effect. It's the idea that exceptional powers, once granted for a noble cause, rarely contract, they only expand. The study points to some pretty chilling historical precedents. The UK's Investigatory Powers Act was initially justified for counterterrorism, but quickly morphed into a broad surveillance tool. In France, post-2015 state of emergency laws expanded into routine, everyday surveillance. In Hungary, national security arguments were used to justify crackdowns on the opposition. Opponents of chat control warn that if the state builds the infrastructure to scan personal conversations for one specific crime today, it is dangerously easy to expand that access for other purposes tomorrow, like monitoring political dissent. Which brings us to a really stark legal and historical irony. For years, the European Union has positioned itself as the global champion of digital rights. I mean, the introduction of GDPR in 2018 cemented privacy as a cornerstone of the digital age. Yet, with chat control, the EU is risking that exact global reputation. By mandating the automated surveillance of private digital communication, critics argue the EU risks legitimizing the idea that liberty must yield to security. This could potentially give authoritarian states around the world the perfect blueprint to justify their own repressive surveillance regimes.
Now, remember that exemption I mentioned at the very beginning of this explainer? There is a deeply frustrating caveat in the chat control discussions that has sparked immense criticism. It's called the politician exemption. Under the frameworks being discussed, politicians, intelligence agencies, and military personnel would be explicitly excluded from the scanning system. Why? To protect their own sensitive information and professional secrets. But this creates an incredible paradox, because if the scanning system is perfectly safe for privacy, as proponents claim, why do politicians need an exemption from it? It sends a pretty clear message. The privacy of the elite is absolute. The privacy of the citizen is conditional.
So right now, Europe stands at a massive crossroads. The temporary extension of Chat Control 1.0 has passed, but the battle over the permanent, mandatory Chat Control 2.0 resumes in September. And those negotiations will define the future of end-to-end encryption and our fundamental right to private digital spaces. Ultimately, it's a choice between the illusion of perfect automated security and the preservation of the liberties that define a democratic society. Every generation redraws the line between freedom and security based on the tools of their time. And with this latest vote, Europe has edged that line just a little further into our private lives. The technology to inspect every message, every photo, and every thought we share digitally before it ever leaves our devices is already here. The question we must ask ourselves as we log on, send a text, or share a photo is no longer whether technology can inspect our communications. The question is whether we believe it should.